Good afternoon, everybody. I'm going to give everyone a few minutes so that people that choose to join and are a couple of minutes behind, we'll let them join. Is everybody having a good week so far for those of us that are here? Good. Very good. Okay, so let us get started. Good afternoon, everybody. My name is Ross Pitkoff of the Pitkoff Law Group. We are a New York City-based commercial litigation and corporate boutique. We help business owners resolve complex disputes between partners, shareholders, and third parties. And we also provide corporate transactional services for our clients. Our attorneys are licensed here in New York. They are also licensed in New Jersey and in Florida. So we do practice in both New York, New Jersey, and in South Florida. So today on our agenda is to discuss the fun and exciting topic of shareholder derivative lawsuits, specifically targeting New York, but generally speaking, these suits can be brought in any of the jurisdictions in which our attorneys practice. So as we get started, first, I will outline what it is we're going to discuss today. So we will begin by talking about the definition and the purpose of derivative suits, what their purpose ultimately is, why they matter in New York litigation. We'll discuss when one can bring a derivative suit and kind of what triggers it. Then we'll look through prerequisites and procedural requirements. What limitations do shareholders have when attempting to bring these suits? We will shift over to a discussion of sample causes of action that one can bring in a derivative suit. We'll discuss the type of relief that can be sought, which is a little different than just general common law claims. We'll talk about some of the defenses that management and officers and/or directors may have when dealing with these types of suits. And then we will conclude with a couple of practical considerations and perhaps just touch upon some key takeaways. Once again, I'm Ross Pitkoff, and I'm looking forward to jumping into this today. If you do have any questions, please make sure to post them. I will answer them at the end of the session. So just because if I'm in the middle of speaking and I don't respond, it sounds like a deposition now, but if I don't respond in the middle of the question, when you ask your question, I will ultimately at the end of the live. So getting started, what is a shareholder derivative suit? So first and foremost, a shareholder derivative suit is a lawsuit brought by a shareholder on behalf of the corporation or an LLC to address harm done to the business entity. The claim generally will make an allegation of some sort of wrongdoing by insiders of the company. And when we say insiders, we mean officers, directors, or controlling members if it's an LLC. And the allegations will revolve around harm that was done to the company as opposed to the shareholders or members themselves. So ultimately, these types of claims are being brought by the shareholders or members of a business. They're not being brought to obtain damages for an individual, such as an individual shareholder, but rather are being brought to seek relief for the corporation or company itself. And that's a very, very big distinction. Now, just a little bit of a discussion on that. Typically speaking, when an individual decides to bring a claim, they are bringing a cause of action. They can do so as a shareholder or a member of an LLC, and they can bring claims against the company and or individual owners of the company, members, officers, directors, etc. And they can make allegations that they've been damaged. We see this all the time, for example, when dealing with class action lawsuits in the securities realm. You will see shareholders bring a claim to allege that the conduct of management has ultimately harmed the value of their stock based upon potentially misleading information, perhaps that duped them to invest in the first place. Yet you can also simultaneously see a shareholder derivative action brought by the same shareholders. And in that instance, you have shareholders that are seeking an action against management of a company, and they are doing so now through the different lens of essentially saying we're suing derivatively on behalf of the company to obtain something for the company, whether that's monetary damages, some sort of relief, whether it's forcing the company itself, the officers and directors, to take action against a third-party vendor who has wronged the company, or to do something else that would cause a benefit to the company and alleviate any detriments. So that's a very important distinction to remember between general actions which shareholders or members can bring against a company versus the derivative suit that's brought on behalf of the company by its owners for the benefit of the company. So when are derivative suits brought or threatened? There's a number of different situations that, again, tend to overlap with individual claims where a shareholder derivative action can be initiated. So some examples of those might sound very common for those of us that are CPAs or forensics or just business owners dealing with business. These may sound common to you. They may sound less common to you if you are not so involved in the business litigation or the practice of running a business or dealing with business disputes. But essentially, fiduciary breaches. Allegations that directors or officers have acted in their own interest rather than the company's interest is a valid claim both in an individual action, but also for a shareholder derivative action. Corporate waste. This can be mismanagement, improper spending of corporate assets, something that an officer or director has done or a member of an LLC has done to cause a detriment to the business from a financial perspective. Self-dealing transactions. These are where insider transactions benefit the directors or officers at the corporation's expense. Therefore, those are often claims that we will see in some sort of derivative claim that's brought. A failure to pursue claims. Those are claims that the corporation has against third parties, perhaps for a breach of a contract where damages should be owed to the company, but for one reason or another, the officers and/or directors have refused to file an action. So seeking some sort of relief to force the company to do so is a means that one can actually attempt to accomplish through a derivative action. And then finally, significant conflicts of interest. This is where management decisions appear compromised by personal interests. So there's this question as to whether or not there's legitimacy to the directions and the ultimate decisions that are being made by the company. So something else that's fun about derivative actions, they are not your typical action where you can simply run into court. So for those of us that are familiar with partnership disputes, it's often that we'll represent a partner against another partner in a company. If there is a need to seek relief, one partner will run into court. If there's emergency relief that's needed, we might seek a temporary restraining order. We might attach bank accounts. We're going to seek an injunction to refrain and stop one of the members from doing something that's harmful to the business. They could be, for example, engaged in corporate waste and mismanagement. We want to enjoin them to stop them pending the outcome of the litigation from continuing those nefarious or detrimental acts. Well, that's all said and good. But now if you are seeking a derivative action, things are a little bit different. So I'm going to break this down right now because, believe it or not, the law is a little bit different for corporations versus limited liability companies. And even if practically speaking, everything's the same, the distinction is nevertheless of value to mention. So corporations in New York are governed by the New York Corporation Law. And specifically, Section 626 provides a requirement on shareholders to ensure that they don't bring an action haphazardly. So there's a few prerequisites that a shareholder in a corporation needs to reach prior to their ability to initiate a shareholder derivative suit. So number one, the plaintiff must have been a shareholder at the time of the alleged wrongdoing or obtain their status as a shareholder through somebody else. So in other words, if, for example, wrongdoing was committed in December of 2023 by an officer of a corporation, and the plaintiff or the presumed plaintiff became a shareholder in January of 2024, there's now an issue. The plaintiff will lack standing to bring the suit because they were not a shareholder of the company at the time that the wrongdoing had taken place. However, if that same plaintiff had obtained their shares from a wronged party and the rights of that shareholder were assigned to this new plaintiff, they then could bring an action so long as they satisfy the other threshold requirements under the New York Business Corporation Law. And by the way, the corporation law, we refer to it as the BCL. So moving forward, I likely will reference the BCL generally as we proceed through this speaking engagement. And forgive me for those of us that are watching, we are also recording for our general social media and our other channels. So we have bright lights on either side of me, which is fun, but it tends to make one somewhat hot under the lights. So that is why you'll see me having some water here and there. Okay, so aside from having proper shareholder status before initiating a claim, the shareholder that wishes to seek a suit, and it can be one shareholder, they must make a written demand on the board of directors requesting that the board take action before they're able to bring a suit. So let me say that again. The demand requirement is that the plaintiff must make a written demand on the board of directors requesting that the board take action before they file a lawsuit. Now, the idea stems from the reality that courts are not business owners. Courts don't run businesses. Courts are not entrepreneurs. Judges are not involved in the day-to-day affairs of a company. So generally speaking, the courts don't want to intervene and meddle with companies. So that's the logic behind the demand requirement. The court will want to see that a shareholder made the efforts to have the board or the officers resolve the dispute prior to coming to court. Now, there is an exception to this rule, and it's called the futility exception. The shareholders are not required to make a demand that the board of directors take action in the following scenarios. Number one, if there is a belief that the majority of the board of members or directors are alleged to have participated in the wrongdoing. If that's the case, then there is no requirement to first go to the board. Number two, if the board members are dominated or controlled by wrongdoers. So if the bad faith actors for whatever took place were actually involved in the company and are controlling or dominating the board of directors such that they're having extensive influence over them, the courts have carved out this exception where one no longer needs to make this demand upon the board, but instead you can go directly to court. And number three, the challenged transaction was not a valid exercise of business judgment. In this scenario, number three, the courts have discussed this rather heavily. There's the case of Marks v. Akers, which is a court of appeals, the highest court in New York, decision from 1996 that ultimately unpacked all of these futility exceptions. And in that case, the court specifically referenced this idea that, well, what do we do in the scenario where a shareholder doesn't want to make a demand because the board's involved in the wrongdoing? Fine, that makes sense. You can run into court. If the board is dominated or controlled by the wrongdoers, that makes sense. No demand needed. You can run into court. In this third scenario, there is now this additional opportunity to go to court without making the demand if it's clear that the judgment or the decision that was made was not a valid exercise of what a reasonable person would do in the position of whatever this wrongdoer was. So the conduct alleged of has to be pretty darn egregious. But if you can show, for example, it's very clear that fraud was committed, then there's no need for the shareholder to go to the board of directors. You can simply initiate an action in court. Okay, so that's the BCL, Section 626. Now, interestingly enough, limited liability companies are governed by the New York Limited Liability Company Law. There is no similar or mirroring specific provision under the LLC law in New York, the New York Limited Liability Company Law, that requires this shareholder to make this demand upon the board of directors before filing suit. However, while there was confusion in the early days of LLCs, which are much newer constructs than corporations, the case of Solis v. Wolf, which was a 2010 decision, once again by the Court of Appeals, established and confirmed via common law that derivative claims in LLCs, number one, can be brought by members of an LLC, and also you're going to see the similar demand requirements required in order for the LLC member to bring an action against the managing members or other members of the business. So ultimately, at the end of the day, the BCL, which governs corporations, and now common law for LLCs, all require that this demand be made unless such a demand would be futile. And in those instances, you can look to the three common areas where a demand would be considered to be futile. So moving on, what types of causes of action do we tend to see in shareholder derivative claims? There are many, which we briefly touched upon before, but ultimately breaches of fiduciary duty, claims for self-dealing. Those can deal with excessive compensation to members or managers or distributions in LLCs that do not seem reasonable or seem beyond the scope of what should be allowed. Corporate waste, unjust enrichment, claims for fraud, misappropriation of corporate assets, and breaches of contract, especially if a director, officer, or member violates a governing agreement, such as a shareholder agreement, bylaws for a corporation, or an operating agreement for an LLC. What type of relief do we often see that individuals that are seeking a derivative action will look for? Well, that really depends. Remember, a shareholder or a member in a derivative action does not seek individual damages. This is not a shareholder's opportunity to say that I'm, for example, owed $100,000 because of the conduct of the company. That's an action that can be brought, but that's separate and apart from a derivative action. So the types of relief that can be sought range, but ultimately the plaintiff can seek monetary damages to compensate the corporation for any losses. The shareholders can also seek rescission of any improper transactions. Similarly, just like you can do in a separate type of action that we've talked about, Injunctive relief is an option to stop ongoing harmful conduct that's harming the company. You can also seek corporate governance changes to improve oversight. And lastly, and particularly in egregious scenarios, one can seek removal of directors or officers that were involved in the wrongdoing in the first place. So, who are common targets of derivative suits? Well, directors and officers will tend to be at the top of the list of those that are the targets of derivative actions. And that's because the directors and officers are charged with the very high level task of overseeing the day to day management of the company. So while the directors oversee the officers are in the grind daily to ensure that those working underneath the officers are doing what they're supposed to be doing. So directors and officers accused of misconduct or breaches of fiduciary duties tend to be targets. Controlling shareholders who are engaging in oppressive or fraudulent behavior can also be a potential target in a derivative action, especially where their conduct is ultimately harming the overall company's health and well-being. Also, third parties who conspired with insiders to harm the corporation could be targets of a shareholder derivative action. If you have a majority owner of a company that's engaged in conspiratorial behavior with a third party, they both can be targets. So these are things to look out for when you are preparing or filing or getting ready to file a shareholder derivative action. Now let's move on to some of the defenses. Because just because a plaintiff or plaintiffs are bringing a shareholder derivative action doesn't actually mean that any wrongdoing has ultimately taken place. Therefore, there are several defenses which the officers or directors or members of a company can allege to justify their conduct and hope to eviscerate the likelihood of success of the plaintiff's ultimate claims. So what are some sample defenses? The big one that's often talked about is the business judgment rule. The business judgment rule is a defense where the defendants can argue that the decisions that they made were made in good faith and within the scope of their business discretion. So this is a very important component of a defense. Whenever you see a derivative action, it's a requirement that the officers and directors set forth a reasonable defense, or I shouldn't say it's a requirement, but it's what one does. And the business judgment rule is often invoked. So now, what are the three specific elements that a defendant can utilize when setting forth the business judgment rule? In other words, what's the court going to consider whether there was good business judgment or there wasn't? Number one, the decision made by the directors or the officers must have been made in good faith. So decisions motivated by self-interest, decisions motivated by fraud or bad faith will not be protected. Number two, the decision needed to have been informed. Directors need to show that they gathered relevant facts, consulted with experts where appropriate decisions were made based upon good and reasonable judgment. And number three, the decision needs to be considered to be in the best interest of the corporation or the LLC. So even if the decision ultimately proved to be unwise, as long as it was made with reasonable care and without conflicts of interest, the court will generally defer to the board's judgment. And this is a ruling that came out, Auerbach v. Bennett, in 1979, a Court of Appeals case where the business judgment rule really came into being. And it was done so because courts have always been very hesitant to allow shareholder claims to continue. And it's a strong belief that corporations should be able to operate without the constant and consistent concern that there's going to be litigation over every single decision that they make. Hence, this business judgment rule defense was put into place as a means of protecting officers and directors and to act as a deterrent to shareholders who otherwise might be utilizing the court system to bring case after case. And yes, for those of you that are familiar with what's taking place in Delaware right now, there is a concern by many companies that shareholder opportunities have grown and grown, such to the point that these types of defenses have no longer the same merit in the Delaware court system. And now you have a scenario whereby officers and directors and companies generally are talking about leaving Delaware. And in fact, many major companies have, to avoid these scenarios where shareholder emboldenment can no longer take advantage of the company's position. And that's why you're starting to see a lot of companies leave Delaware and go to other jurisdictions. Okay, but I digress. That's a little bit of a sidetracking there. So moving on from that, aside from the business judgment rule, there are other defenses that officers and directors and members of an LLC can initiate when they are defending a shareholder derivative suit. One is demand made and refused. If a shareholder has made a demand and the board properly investigated the demands and refuse to pursue claims, this can potentially bar a suit. Now, the courts have also had to dive in detail into the scope of some of these demands made and refused offenses. And the idea is if a board of directors, for example, obtains or hires a separate independent board to investigate, review, and ultimately make a recommendation, the courts are generally going to adhere to what that recommendation is because, again, they don't run this business. They are not involved in the day-to-day. They haven't been brought in to specifically oversee all of the internal dealings of a company. So if there's an independent third-party board of directors that's been pieced together for the purpose of conducting an investigation, the recommendations generally will be followed. However, if there are allegations that this quote-unquote independent third-party board is not so independent, then the court has the will scrutinize whether or not there was such independence with respect to this third-party board. It's similar to a special counsel being appointed in the government, where they try to find somebody who's independent and supposedly does not have political leanings. So just imagine this in the business setting, where if there are concerns that there's a lack of independence, the court can scrutinize this. But if there aren't, then ultimately the court will listen to that determination that was made most of the time by this special board that was pieced together for a particular purpose. Another defense would be lack of standing. The defendants can argue that the plaintiff does not have proper standing as a shareholder or a member, perhaps because they were not a shareholder or a member at the time that the wrongdoing took place. Also, if a shareholder or member does not make the demand upon the corporation or LLC, and they do not show that there was futility, in other words, those topics we discussed before when they don't have to first make the demand, then the case could ultimately be dismissed because these are stringent standards that need to be proven and showed or had taken place prior to the initiation of an action, unless there is that futility. Ratification is another one. The corporation shareholders may ratify the alleged misconduct, and that could potentially preclude the claim from moving forward. Now, that's a complicated scenario because ultimately, in scenarios where shareholders have gripes with the business, if it doesn't arise to fraud, if it's not egregious and severe, and a majority of the shareholders ratify the conduct, even if certain shareholders didn't feel it was right, ultimately, that may preclude the ability of the shareholders to proceed in a derivative action. Because once again, the courts want to see companies self-governing. They do not want to meddle too far, less changes in Delaware, which are taking place, but that's a separate conversation for a separate time. However, when there are claims of fraud or something severe, something highly detrimental, then even if the majority of the shareholders ultimately ratify conduct, that may very well not be enough to preclude a claim under a shareholder derivative theory of liability. So these are important things to look for. Another potential defense would be the statute of limitations. So derivative claims in New York generally follow the applicable limitations for the underlying causes of action, whether it's a breach of contract, whether it's a breach of a fiduciary duty, or associated claims. The statute of limitations that otherwise provide for a limitation for when you can bring a case ultimately do extend to derivative actions. So that's pretty much a summary of derivative cases generally. I think one of the big takeaways here is that shareholders are always in a position to get data and information concerning what's taking place with the company. Ultimately, as time goes on, shareholders may become disgruntled and they may seek to initiate an action. Now, a big component that we've seen of late, and what the courts have touched upon in various cases, is that what if it's just one shareholder? You have one single shareholder that ultimately is interested in pursuing a claim because they believe there was wrongdoing, but none of the other shareholders join in. Well, one shareholder can bring a derivative action on their own. However, it's often far more helpful when multiple shareholders come together, and in fact, a majority of the shareholders or members of an LLC actually have a fortified front and are moving together, because the court will take this into consideration to really consider the extent of what the alleged conduct is and the extent of how bad the alleged conduct truly is. And that's pretty much a summary of the ultimate underlying claims for shareholder derivative actions. I hope that this was helpful. Let me just take a look at some of the questions that have come in. If the shareholders are in the state of Connecticut, but the company is located in New York and has a primary residence in New York, can the action be brought in New York? Okay, so we do have a question. This question concerns whether or not it's really a jurisdictional question. If shareholders are a company located in the state of Connecticut, but the company itself is actually located in New York, does business in New York, its principal place of business in New York, can the shareholder derivative action be brought in the state where the company is located? The answer is yes. And frankly, in a scenario like this, typically with jurisdiction, you can bring the action in either state. So it could be brought in Connecticut, it could be brought in the state of New York. But ultimately speaking here, when you're dealing with a company that has residence in New York, that's taken advantage of the laws and protections that the state of New York affords, it sounds like its bank accounts are highly likely located in New York. And especially if its directors and officers are in New York would probably be the proper forum for that action to proceed, though either might work based upon some analyses that would need to be provided. So I hope that's helpful. Okay, that's another good question. So this one comes from Mark. Can you bring a shareholder derivative action for a privately held company, a publicly held company, or both? So the answer is both. Derivative actions are not limited or precluded based on whether or not a company is public or private. In fact, believe it or not, you could have two partners in an LLC, for example, as members, and one partner can sue derivatively the other partner on behalf of the LLC. We see that it's not very uncommon, but it just goes to show you that despite the fact that you do hear about publicly traded companies, Fortune 500 companies, all dealing with shareholder derivative actions, these can also be brought by individual actors that are dealing with privately held companies and sometimes have some very similar situations they're dealing with respect to the conduct of bad faith actors. Very good. Okay, let's see. We have another one here. Okay, so this question comes from Rachel. I think I understand what you're asking. So in a scenario where you have shareholders of a company and, okay, but it would be LLC managed. Okay, so this is actually for an LLC when you have members of the company that are not receiving distributions, minority members of the company not seeking distributions, but we know that the majority members are. Is this a claim that you can bring individually, or do you bring it as a derivative action? The answer is it depends. In such a scenario where we know that certain members of a company are taking distributions for themselves at the expense of the other members technically have an individual right to pursue those claims because they now have lost out on compensation that they're entitled to. At the same time, one could argue that the company is now suffering because there is self-aggrandizement of these members that are walking away with cash considerations that they shouldn't be at the expense of other members. Ultimately, I would need to hear more information, Rachel. This certainly could be an individual claim, but there might be a scenario, depending on the totality of some other facts and circumstances that have taken place, where it would make sense for a derivative action to be the preferred course of action. So again, the answer at the end of the day really depends. All right. Well, I don't see any other questions. So thank you for those who participated. For those of you who showed up, I want to say I really do appreciate you taking the time. I hope this was valuable. I'm also glad we were able to get back on track after missing a month last month. So please, when you see this online, like, comment, and share. Leave your comments about what you thought. Feel free to send us an email. And if you guys have any requests for what you'd like to see next time, let us know, because we're here to provide value. We're here to sort of bridge the gap between the mystification of what the law is and just practical business sense. So we're here as a resource for you. You can always contact us, and we thank you for your time. So I'm signing off now, Ross Pitkoff, and thank you once again. Take care.